before the current civilization, that the time to stop this madness in Meru has come. And if there is no reason, if we haven't proved or satisfied you, the governor is the bishop in the Holy Book. In the event we have not persuaded you on the evidence, Mr. Speaker, I hope we have persuaded, wherever the truth lies, there is an unsustainable crisis in Meru. And even if you must jettison one person to save the ship, called Meru County with the 1 million inhabitants, your act is still justifiable even under the Holy Book. I now cede the floor to Mr. Jacob Ngwele.
Just to remind you, Council, your time terminates at exactly 8:50.
Thank you very much, Honorable Speaker. My name is Jacob Ngwele. I'm an advocate of the High Court. I've been given this onerous responsibility of taking the House through the evidence which has been submitted before the August House. Mr. Speaker, the Senate is sitting here pursuant to Article 181 of the Constitution, which provides for removal of a governor from office. The question which arises and which begs this House to look at, what is the standard which this House should apply on the evidence which has been submitted by the County Assembly of Meru? My learned colleague, my learned senior, Elisha Goya, when we started, he did inform the Senate that this House is sitting in quasi-judicial proceedings. I beg to differ. The test applicable when you're evaluating the evidence which has been submitted here has already been established by the Supreme Court in 2 cases. That is, the first one is the case of Wabora, and the other one is Mike Mbuvi case, whereby the court was clear that impeachments are a tool of political accountability. Impeachments are not criminal, neither are they civil proceedings. And therefore, the standard, the applicable standard before this House has already been established, that the burden of proof, the standard of proof, is slightly above that for civil cases. That is on a balance of probability and below the beyond reasonable doubt. So we are not, this House is not evaluating the governor's criminal culpability, but it is subjecting the governor to political accountability. Political accountability for the actions of the office which she occupies and the deeds which she has undertaken throughout that period of time. It is our submission that the county